Kenyan. I did a video sometimes last week where I shared that house helps are supposed to, according to the minimum law wage, house helps are supposed to be paid a minimum of 18,000 if you are on major towns. Major towns are like Nairobi, Kisumu, Nakuru, Eldoret, Mombasa. And then for smaller towns, which are like, now let's say Ruiru, Kiambu, they are considered smaller towns, you're supposed to pay 16,000. And then for rural areas, you're supposed to pay 9,000. And it sprung some debates, and then a lot of people were asking some questions in the comments, and I've just decided to answer them in this video. So I have the questions here on my phone. So the first question someone asked was, though some of the questions are similar, what if she pays in cash, no contract was signed, because that's what many people practice. How would that be? So basically here someone is saying if someone is paying the money in cash. So here what I would say from a legal perspective, this will be dangerous to the person employing the house help. Because remember, if you're paying in cash, that means you don't have evidence on your end that you're making payment to the employee here being the house help. So that's dangerous. So I will never advise someone to do that, because now you will not have proof of payment. And remember, as long as the employee proves they were working with you, that would be a disadvantage on your end. So remember here, you'll be taking a big risk on it, because so you'll be bagging on the employee, either the house help either never going to court, the house help either never having evidence to show that they worked for you. And remember, evidence is not plus witnesses. So if the house help has good, reliable witnesses, that is enough for them to just confirm that yes, I know this house help, and yes, even my house help, let's say even a neighbor who has also a house help and they are friends, they can use that as evidence. So that this is it can work maybe if you are so sure that the house help is not going to have evidence, but now that's so dangerous, and I can never advise someone to do that. So that's the risk here, and I've said many people practice it. So the risk here is you might end up even paying now the entire amount, because you remember here you don't have evidence you've been paying any money. So if this person even argues that you've never paid them, for you don't have evidence to show that you've paid, so they might seek the entire 18,000. So that's another, it's a big risk on your end. So I would not advise that if it was me. So the other question number 2, should we not consider the accommodation and food that the maid gets as part of the earnings? So here, remember, remember a house help, this is something maybe I didn't share in the other video, is that a house help is considered like a normal employee. So remember, just any employee, let's say for instance, if it's an associate working in a law firm, if this associate is paid under the Employment Act, you're mandated to provide this person with something like house allowance. I've talked about accommodation. You're supposed to provide this person house allowance. So the fact that you're already paying the 18,000, remember, that's why if an employee is not living within your premises, you're supposed to even provide house allowance to this person. So the fact that that 18,000 does not include, so you providing accommodation and food does not mean that you're supposed to pay this employee below 18,000. It's not factored in. That's something you're supposed to provide separately. But now because this person is living with you, it's considered that you're already catered for that. So it's just like normal employment. So it's just like your employer paying you less money and claiming that, and maybe this employer gives you food, and then they start claiming that, because we are paying you less because we are giving you food. So that's something. So I hope that has answered that question. Question number 3, someone has asked, what if she or he signed a contract agreement of 4,000? So remember, under the law, there is a law already stipulating that what the minimum wage is. So under the law, if there's anything in a contract, in an agreement that goes against the law, that contract itself is considered unenforceable in a court of law. It won't be enforceable. So legally, laws are created for protection of any party is being protected. And it doesn't, because if court allows this, that will mean that everyone will be going against laws in case. So there's no, so to answer your question, no. It won't, you still have to pay 18,000. If you are paying 4,000 and there's a contract, that's not enforceable. Basically, that contract is unenforceable. So if you take that contract to court, if let's say the health center takes you to court and you now produce that contract, it won't be enforceable. you'll be made to pay the balance of, so 18,000 minus 4,000, and if it's 16,000 minus 4,000 for smaller towns, and 9,000 minus 4,000 for rural areas. So a contract that goes against the law is unenforceable. It can't be enforceable in a court of law. Okay, what of those earning 20K? Does it mean that they cannot employ anyone? Willing seller, willing buyer. This was a very common, something I noticed was very common. Everyone was saying willing seller, willing buyer. So basically, willing seller, willing buyer. So that means if the person is willing to get the amount they are being given, so there should not be any consequences. Again, as I've stated, any agreement, whether oral, even if you do it orally, or any agreement that goes against the law is unenforceable. So that means that cannot protect you in any way. So if you're earning 20K, then you've said your earning is 20,000. So unless maybe you start, you get, and it's like kupatia watu solutions. Watafute pesa wakuje niwape solutions. So to okay, I think nishajibu willing. Let me take it again. Saki kupatia watu solutions, ndio mtu akutafute for solutions. Wakili, someone has asked Wakili, what of those earning 20K, does it mean they cannot employ anyone willing seller, willing buyer? This was very common, willing, everyone was talking about willing seller, willing buyer. Please note that as I've already stated, if you enter a contract that goes against a law that has been stipulated, so long as that law exists, it's considered, it will be unenforceable. So it doesn't matter. So if you're going against a law and it doesn't matter whether it's an oral, you enter into it verbally, it doesn't matter. Even if that person came to you and they're the ones who offered, then you've said willing buyer, willing seller, willing buyer. That will not like protect you in case now this person decides to sue. So the other question, someone asked, how does this impact employment bureaus who offer house services in case their wage is below minimum but paid to the bureau? Does this risk transfer save the person receiving the nanny service? So by then this one can protect you in a way because you are not hiring the nanny directly. So the people who will be sued here is the bureau service, because remember you are not paying the nanny directly or the house help, you are paying the bureau itself. That's why when most employers, it's a common thing also, some employers when they hire, they don't hire employers directly, they use an employment agency that will provide them the employees. So for some reason, yes, to an extent, but remember I normally say context is different, but generally, on a general context, this will protect you because remember if someone has to sue you, that person has to prove that you have been paying them, but for you, you have not been paying them directly. So the only person maybe who can sue you here is maybe, so the nanny can sue the bureau service, because now the bureau services are the ones who will be paying them directly, not you. So I hope that one has been answered well. So the other question someone has asked is, if the employer is the one earning 20K, how will the person pay the house help 18K? That's another thing I was telling you. The law has already been stipulated. Remember, this is a law that has already been stated. It's already existent. But then it has been existent for so long, for so long. It's just that people are not aware of it. People are assuming because it blew up this year in 2026, people are assuming that the law was created in 2026. No, actually, even the reason people are knowing about the 18K, it's because what the law just did, it wasn't created, they just increased it from 16,000 for major towns to 18,000. Initially for major towns it was 16,000, it was just increased to 18,000. So this is the law that has been existent. So if you're an employer earning 20K and you cannot pay that 18K, so the thing here is, remember the repercussion will only come in if the house help sues you. But before that, most people don't suffer the consequences. But just know this is a law. I think people assume this is a law that was just created. Remember, the law is already existent. So a lot of factors were considered. So if you're paying 20K and you just court will not factor that in. Court will just look at, has the law been broken? And what does the law stipulate? A house help is supposed to be paid 18,000 for major towns. So if you're in a major town, even though you're earning 20K, court will not look at your earning, court will look at whether you've broken the law that has already been stipulated. So question number 7, someone asked, hii ni story ya willing buyer and a willing seller, just make a contract. That I've already answered that. Please note that a contract that goes against the law is unenforceable. So even though you enter a contract, both parties sign, it's a well-executed contract, if you bring it before court, it will not be enforceable because it goes against the laws. laws have been created for a reason. So you can't start creating, because court cannot set, this is something that court cannot set a bad precedence whereby they create laws and people can create their own laws in contracts. You can't create a law that's against, you can't create a contract that's against the law. So question number 8, the last question, does the employer have the capacity to pay? Context is essential. Again, I think I've already answered this in another question, is remember, it doesn't matter. This law has already been stated, it's already in existence. So when you are paying someone below the minimum wage that has been stated by the law, court will not be asking whether the employer has the capacity. Court will be looking at, has the law been broken? Has the person gone against the law of minimum wage whereby you're supposed to be paying someone 18,000 or 16,000 or 9,000 depending on where you are situated. So just know that the law has been created, so it doesn't, the capacity to pay is not a factor here, unfortunately. That's the sad reality. The capacity to sue has not been there. This is law that has been there in existence. So I think those are the questions that people had asked. So I hope we have at least answered majority of the questions, because most of them were related to this. We just broke it down to 8 questions. So thank you for engaging in our content here.